A very good morning. I am Saakshi Rajput, studying in KRS Kokte Institute of Technology, Department of MBA. My topic for the presentation is Intention to Create Legal Relations. Let us first look at certain basics. What is a contract? According to Section 2, Subclause H of the Indian Contract Act 1872, a contract is an agreement which is enforceable by law. An agreement is an offer plus acceptance. When one party or one person makes an offer to another party or the second party, and the second party accepts the offer which is made by the first party, then it is called as an agreement. But is an agreement enforceable by law? No, an agreement is not enforceable by law because it is not a contract. A contract is when an agreement also has enforceability by law. The agreement needs to have certain validation from the court of law. Only then the agreement shall be enforced into the court of law, and then the agreement can be called as a contract. Now let us understand certain essential elements of a valid contract. Without these elements or these characteristics, a contract shall not be agreed upon as a valid contract. The first point is agreement, that is offer plus acceptance. As I earlier said, when one party makes an offer to the second party and the second party accepts the offer which is made by the first party, then it is called as an agreement. The second point is agreement not declared to be void. There are certain agreements which the law or the court of law declares to be either illegal or void. Certain agreements are prohibited by the Indian Penal Code, that is the IPC, like for example a threat to commit murder, which are opposed to the public policy and which are illegal in nature. Such agreements are declared to be void in the beginning. The third point is lawful consideration. When two parties enter into a valid contract, both the parties should get something in return and also give something in return. So this is called as lawful consideration. The fourth point is a lawful object. The main object or the main idea of coming into a contract should be lawful. The object or the main purpose of entering into contract should not be illegal, immoral, or which is opposed to the public policy, like for example a murder or committing a crime or committing a theft or kidnapping someone, etc. So such objects or such ideas of entering into contract shall not be treated as a valid contract. The fifth point is free consent. Two or more parties can enter into a valid contract only if both the parties have entered into a contract without any coercion, without any force, or without any undue influence, by making fraud or by misrepresenting something or by mistake. Both the parties should enter into the contract only with their free will and wish. You cannot force a party to enter into the contract, or you cannot misrepresent, like how they show in the movies, like when a person is not conscious, you just take signature of the person who is sleeping and then you enter into the contract. Such things are not considered to be a valid contract. So if you want to enter into a contract with a person, there has to be free will and wish to enter into the contract. The sixth point is legal formalities. According to the Indian Contract Act 1872, there are certain legal formalities that has to be maintained and that has to be followed in order to make a valid contract. Like for example, a contract has to be in written, it has to be registered, etc. The seventh point is capacity of the parties. When you want to enter into a contract, you have to enter with a person who is of an age of majority. That is, a person who is above 18 years of age, a person who is of a sound mind, and a person who has not been earlier disqualified from contracting by any law, etc. You cannot enter into a contract with a person who is below 18 years of age, a person who is of an unstable mind, who is of a little who is of an unstable mind or of an unsound mind. You cannot enter into a contract with a drunkard or with a person who has recently got some medical issues, etc. So there are certain capacity, only with those people you can enter into contract. The eighth point is certainty. The agreement or the contract that is going to be made has to be certain. It shouldn't be uncertain or any unrealistic projects, etc. Like as I said before, the agreement should not be declared as void. You cannot make contracts like regarding a murder or regarding any other illegal or immoral activities in the society. The ninth point is possibility of performance. Like as I said before, the contract should be possible of performance. The contract should not be any illegal, immoral, or any other activity which is opposed in the public policy, etc. So if you want to enter into a contract, it has to be a valid performance which can be helpful for the society instead of going against the society, etc. So a valid contract should be possible of performance. The 10th and the last point, the important element of valid contract is the intention to create legal relations. Both the parties, when they are entering into a agreement, when they are entering into a contract, they have to also have an intention to create legal relations. When both the parties create legal relations, they are bound to face any legal consequences or legal problems against them if there is a breach of contract, or if one party fails to perform the performances. Hence, there has to be an intention to create legal relations in order to keep the contract safe and secure. So now, as we know the little bit basics about a contract, let us move forward with the main topic, that is the intention to create legal relations. So what is an intention to create legal relations? It is defined as an intention to create or to enter a legally bound contract. So when two or more people are entering into an agreement, if they want to turn the agreement into a contract, they have to enter into a legally bound contract. It consists of the readiness or the willingness of the parties to accept the legal consequences of having entered into the contract. So when two or more parties enter into the contract, they have to be ready to face and to accept the legal consequences after entering into the contract. Suppose two parties have entered into an agreement, have entered into a contract, and one of the party fails to perform the performance, or they perform a breach of contract. In such cases, the other party which has faced certain problems due to the breach of a contract can file a case against or can sue the party which has performed the breach of contract. So in such cases, the party which has performed the breach of contract has to be ready to accept the legal consequences that he or she might face. So this is the main intention to create a legal relation. That is, you can file a case against or you can sue the person who has hurted or who has breached the contract. So this is called as the intention to create legal relations. Now let us understand certain reasons so as to why we have to create legal relations. Number 1, without creating legal relations, the parties cannot sue each other. So on day-to-day basis, every person as a human being, we enter into various agreements and contracts. So like for example, your friend has invited you for a birthday party and you also tell him yes that you will be present tomorrow at his house to celebrate the birthday party. And then your friend, he prepares lots of varieties of dishes, and then he also decorates his entire home and he is ready to celebrate the party. But next day, due to some of your personal problems, you couldn't attend the birthday party. Now your friend is very furious and he has become very angry, and now he wants to sue you because you have not attended the birthday party. Your friend also wants to get some kind of a compensation from you because you have not attended the birthday party, and so much of his money and so much of his efforts have gone into vain, is wasted. So now, but your friend cannot sue you because you guys have not entered into a contract. You guys have not created legal relations. It was just an agreement between two friends. The one friend said that one friend called the other friend to the birthday party, invited the other friend to the birthday party, and the other friend tells that he shall come to the birthday party. But since there was no legal relations, the parties cannot sue each other. Hence, the first important point is, without creating legal relations, the parties cannot sue each other. The second point is, without creating legal relations, the contract would not be enforceable in the court of law. Like the second point is quite similar to the first point. So if you want your contract should be enforceable in the court of law, if you're not sure about the party that he or she may perform the contract, etc. So if you want to get some kind of surety and some kind of support, you have to prepare a kind of a legal relation in order to get the validity and in order to perform your contract in front of the court of law. So this is the second point. The last point is, without creating legal relations, the contract is just a mere promise. So like I had given you example of the birthday party. Both the friends had not created a legal relation. They had not performed a contract. They have not entered into a contract. It was just a promise that one friend told his another friend that he will come tomorrow to the birthday party, but he didn't come due to some of his personal problems. It was just a promise made two between two friends, etc. So if you don't create legal relations, the contract will be just a promise. It is just an agreement. You cannot create legal. You cannot sue each other, or you cannot present your case in front of the law. So these are certain points why you have to create legal relations. Now let us understand the four classes. So there are four types of agreements in which some agreements parties do not intend to create legal relations, and in some agreements parties do intend to create legal relations. So the first one is social agreements, family or domestic agreements, business agreements, and commercial agreements. Now let us understand each one of them. The first one is social agreements. Like how I said earlier, I gave you the example of two friends. One friend was invited the second friend for a birthday party, but since the second friend could not show up to the party, the friend whose birthday celebration was there, he wants to sue the other party for compensation. But the friend cannot sue him because it was just a social agreement. In social agreements, when parties enter into agreements with their friends, with their relatives, or with their neighborhoods, and with their colleagues, etc., when there is a kind of social relation with two or more people, people do not intend to create a legal relation or a legal contract. Hence, in case of social agreements, parties do not intend to create legal relation. The second one is family or domestic agreements. So in case of family or domestic agreements, that is agreements between a husband and wife, a father and a mother, or a brother and his father, or a mother and her daughter, etc. So in such cases where there is family relations involved or domestic relations involved, here also people and parties do not intend to create legal relations. Like there was a case where both husband and wife, they go for a vacation, and due to some illness the wife had to stay back and the husband had to go back to their hometown in order to work. And the husband also promises the wife that monthly he will be sending her certain amount of money. But due to some problems, the husband could not send the wife some money during one particular month, etc. So the wife decides to sue her husband because her husband did not send her some money for one particular month. But then the court told the wife that the wife did not, both the husband and wife did not intended to create legal relations, and you guys had not prepared a contract. It was just certain consequences that you guys faced, and all of that. So the court decided not to sue the husband, and the wife lost the case. So in such cases, people do not intend to create legal relations. The third one is business agreements. In case of business agreements and commercial agreements, both of them are a little bit of similar. So I will take both of them together. So in case of business agreements and commercial agreements, the transactions incur with a strong presumption of a valid contract. These agreements, where the parties deal as they were strangers, are presumed to be in binding. So in case of business and commercial agreements, where the agreements are going to be very serious in nature, so in such agreements, both the parties intend to create a legal relation. Thank you.